What this case really represents is a clash of history and law. We have a history of not the worst, but maybe not the best treatment of Aboriginal people on the planet. There are legacies of that experience. One of the big issues of the 1970s was that the courts should deal with this legacy of Indian lands, of Aboriginal rights. And this is what happened in BC especially, where the position of the Crown and politicians was, you have no rights, you have no lands, too bad, so sad. And they opposed that, and they made some gains, and treaty people made gains by litigating treaty rights. Not always. The same arguments wouldn't necessarily hold in slightly different situations. And then you have the whole struggle for constitutional recognition and constitutional protection to existing rights, whatever they might be. And rather than go a negotiation route, we have had a piecemeal journey through to the Supreme Court on a number of issues. There are often really surprising victories, but often there is really incomplete outcomes, and the foundations to me often seem to be ad hoc. So on one level there's a clash between history and law on what should be and what has happened, and then the other problem is just the use of history in courts. For the Métis, the cases that they have tended to win against the odds have been cases where they've used a lot of historical documentation, and they haven't said to themselves, the documents speak for themselves or the facts speak for themselves. And if you stop and think about that, that's a very, very, I think it's in some ways the most reactionary notion. Is it not only is it intellectually superficial, but it also doesn't recognize that most of these documents were written by white people. Most of them were written by colonial authorities at one level or the other. Now, they weren't necessarily bad people. On some instances, they could be quite empathetic. And also, they were not necessarily writing for a posterity of how people might think today. They often wrote in very candid and explicit terms and made very big admissions on the question of script. There's all kinds of references to fraud and forgery and impersonation. It's there in the Crown's own historical records. However, given that situation, I think it's most, not only methodologically and ideologically problematic to say the facts speak for themselves, I think it's admitting, it's like forgetting altogether one of the biases in these historical records, which is they're not the records of the people, they're the records, by and large, of forces of colonialism. So I think that if you go forward with this notion that the facts speak for themselves, that lawyers understand history better than any historian could ever understand history, then it's going to be hit and miss. And in this case, the MMF case, it was predominantly misses. In the other cases where historical evidence, archival records, considerable archival and historical research, and a variety of expert witnesses have been used, have generally had more favorable outcomes. It's not necessarily a recipe for success 100% of the time, but it has worked in circumstances where it really was what some lawyers and activists would call a hard case. Like in Northwest Saskatchewan in the 1990s, prior to the Pauley decision, we put in some script documents, and the judge thought about them very seriously and pointed out that contrary to the Crown's argument that extinguishment of the right had occurred, there's nothing in black and white on these documents that say extinguishment of a fishing right occurred. So I think this is an ongoing thing. I think it's complicated by the fact that courts seem to take an ad hoc remedy approach to these very fundamental contradictions between Aboriginal people and colonizing forces, and the history has to be taken more seriously.